EB-5, Immigration Through Investment. The EB-5 program provides a method for eligible immigrant investors to obtain a green card and become permanent residents of the United States. This is a job creation program in which a person should make an investment at risk in a U.S. business. The required investment is at least $1.8 million. If the investment is in high unemployment or rural areas, then the minimum investment requirement is $900,000. Regardless of the amount, the EB-5 investment must lead to the creation of 10 full-time U.S. jobs for Americans or permanent resident workers. Investors have the choice to invest in their own business or in regional centers. 1. As an individual, direct. If the applicant invests as an individual, must find their own project to invest in, must take a direct managerial role in overseeing their investment project. When investing in their own entity, investors are responsible for the creation of the 10 full-time jobs and the successful operation of the business. 2. Through an EB-5 regional center. Regional centers are private entities pre-approved by the government to receive the funds from foreign investors. Have USCIS designation to administer EB-5 investment projects. EB-5 investment through a regional center carries several advantages. Regional centers are subject to more flexible EB-5 job creation requirements and can also typically pool greater investment amounts by attracting multiple investors. When investing in a regional center, the investor is usually a limited partner together with other investors, which have a more passive role. Regional centers usually develop large real estate projects, and the government allows them to count direct, indirect, and induce employment through an economic analysis. It is important to highlight that either investing in their own business or through a regional center, investors are required by law to invest at risk. That means that there is no guarantee of return of the investment. The EB-5 process is divided into 3 steps. 1. Submit Form I-526, which includes choosing the U.S. business entity that they would like to invest in, making the required capital investment in the chosen business, demonstrating that the funds invested have a legal origin, that the business entity can create the required jobs. 2. Once the I-526 is approved, the beneficiaries can apply for adjustment of status if present in the U.S., or through a U.S. embassy or consulate abroad if not present in the U.S. In this stage, the person must demonstrate that he does not have a serious criminal background, that he did not violate immigration laws, and that he is healthy. Spouses and children under 21 years of age can apply with the main beneficiary and travel permits, which are requested while the government processes the case. The foreign national can only apply for a green card if there's currently a green card available. Determine if there is a green card available by checking the visa bulletin, issued monthly by the Department of State. 3. If approved, applicants are granted a 2-year conditional permanent residency. 3 months before the expiration of the green card, the investor must file Form I-829 to remove the conditions. In this last stage, the investor and the company must prove that they have successfully met all EB-5 program requirements. EB-5 investors are granted unconditional permanent residency once the I-829 application has been approved. EB-5 investors have the opportunity to become United States citizens after they complete the EB-5 program. To qualify to become a U.S. citizen, the EB-5 visa holders must first be permanent residents for at least 5 years. Then, the EB-5 visa holder can go through the naturalization process, which enables them to become United States citizens. Which is why it is even more critical you select a very experienced immigration attorney. Gower Law Firm.